Rule 110, Prosecution of Offenses. Section 1, Institution of Criminal Action. What is criminal action? Criminal action can be found in Rule 1, Section 3. Is one by which the state prosecutes a person for an act or omission punishable by law. If you are going to file your criminal action, there are two ways. First, in outside of Metro Manila. And outside of Metro Manila, you have at least 4 years, 2 months, and 1 day. Without regard to the fine, the PI is required to be conducted. PI is required to be conducted before the filing of complaint or information for an offense where the penalty prescribed by the law at least 4 years, 2 months, and 1 day. By filing the complaint with the proper officer for the purpose of conducting PI. If you are going to file your complaint, you are going to file to the city prosecutor for the purpose of conducting preliminary investigation. Dayon, ang opposite is less than 4 years, 2 months, and 1 day by filing a complaint or information directly with the MTC or the complaint with the office of the prosecutor. Ikaduha, in Metro Manila and other chartered cities, the complaint shall be filed in the office of prosecutor unless otherwise provided in their charters. So the question is, how do you institute criminal action? The answer is, it depends. So what is the effect? The effect of the institution of criminal action shall interrupt the running period of prescription of the offense charged unless otherwise provided in special laws. Section 2, Complaint or Information. What is complaint? Complaint is a sworn written statement charging a person with an offense. Information, an accusation, writing charging a person an offense subscribed by the prosecutor and filed with the court. In Section 5, Prosecution in Criminal Action. The question is, who tries criminal case? The answer is the public prosecutor, but of course, this is only the general rule and there is an exception. The exception is the private prosecutor may be allowed to try also a criminal case. And Section 5 also talks about private crimes like adultery, concubinage, seduction, abduction, and acts of lasciviousness. Who must prosecute criminal action? All criminal action commenced by a complaint or information shall be prosecuted under the direction and control of the prosecutor. Who is private prosecutor? Is the lawyer hired by offended party, but if there is a private prosecutor in criminal case, the role of the private prosecutor is to supporting the public prosecutor. Hindi siya pwede magiging bida dahil ang bida lamang ay si public prosecutor. But in Section 5, telling us also that your private prosecutor can become a leader in a criminal case. But what are those instances? First, if the public prosecutor has a heavy work schedule or in the event of lack of public prosecutors. The rules also requires you to get two things. First, it must be written authority should be coming from the Chief Prosecution's Office or the Regional State Prosecutor. Aside from the written authority, it must be approved by the court. And these are the requirements to the private prosecutor. Take note, once authorized to prosecute the criminal action, the private prosecutor shall continue to prosecute the case up to the end of the trial, even in the absence of the public prosecutor, unless the authority is revoked or otherwise withdrawn. Section 6. Sufficiency of complaint or information. So there are 6 states that first, name of the accused, second, designation of the offense given by the statute, third, acts or omission of us constituting the offense, fourth, name of the offended party, fifth, approximate date of the commission of the offense. The last is place where the offense was committed. Rule 111, Prosecution of Civil Action. Section 1, Institution of Criminal and Civil Action. In general rule, when a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charge shall be deemed instituted with the criminal action unless you can separate the civil action to from the criminal action. When does this happen? There are 3 instances. First is the offended party waives the civil action. Second, reserve the right to institute it separately. Third, institute the civil action prior to the criminal action. So what is the basis? According to Article 100 and RPC, every person criminally liable for a felony is also civilly liable. Take note in the first instance, if you waive the civil aspect, but what is the effect? According to Section 16, the offended party can no longer intervene by counsel in the prosecution of the criminal offense. Question: what is your strategy if you are a private lawyer hired by the offended party? The answer is you can claim the damages even if it a little just for you to intervene. In the second instances, the offended party will make a reservation because from that scenario, offended party was very angry to the accused and she or he want him to give a lesson. The question is, when do you reserve the civil action? The answer is before the prosecution start presenting its evidence and under circumstances affording the offended party a reasonable opportunity to make such reservation. Exception: no reservation to file such civil action separately for violation of BP 22 shall be allowed. On the last instances, it talks about the civil action filed ahead shall be suspended in whatever state it may be found before judgment on the merits. Take note, the suspension shall last until final judgment is rendered in the criminal action according to Rule 111, Section 2. If the criminal action filed ahead, the civil action cannot be instituted until after the final judgment, according to Rule 111, Section 2, Paragraph A. Rule 112, Preliminary Investigation. Section 1, what is preliminary investigation? Is an inquiry or proceeding to determine whether the sufficient ground is engendered to well-founded belief that a crime has been committed and the respondent probably guilty thereof and should be held for trial. Well-founded belief means probable cause. So from this scenario, in the case of Denise Cornejo and Mr. Vong Navarro is not yet an accused. He is respondent. Kung atong mabasa ang ilahang pleadings, ang nakasulat dito is Denise Cornejo as your complainant or she is an offended party versus Mr. Vong Navarro as respondent. O dili na to matawag nga people of the Philippines because This is just an inquiry. Wala pa masaka sa korte. Kumbaga, ito pala yung first stage ng preliminary investigation. Take note, when the prosecutor dismissed the case of Mr. Vong Navarro or dismissed the case of Ms. Denise Cornejo, it says that according to the investigation of the investigating prosecutor, according to Section 4, stated that there is no reasonable ground to believe that the crime of rape has been committed and Mr. Vong Navarro is not guilty thereof. In Section 2, who are the officers authorized to conduct preliminary investigation? First is the provincial or city prosecutors and their assistant. Second is national and regional state prosecutors. Third are others officers may be authorized by the law, just like the COMELEC officials has a power to investigate, and also the office of the ombudsman. When preliminary investigation required, before the filing of complaint or information for an offense where the penalty prescribed by the law at least 4 years, 2 months, and 1 day without regard to the fine. Question: ang tanan bang kaso sa RTC kay moagi og preliminary investigation? The answer is yes, of course, definitely, because because the case to be filed in the RTC, the penalty is about 6 years and 1 day. How about MTC cases? You have to qualify because not all MTC cases will undergo PI. Only where those penalty is 4 years, 2 months, and 1 day that PI is required. Of course, no PI. Opposite, if the penalty less than 4 years, 2 months, and 1 day, so dili na kailangan og PI. Example cases in MTC less than 4 years, 2 months, and 1 day is malicious mischief. Only Aristo Mayor. Procedure filing a complaint. Who files a complaint? Is the offended party your complainant? What the next step? There will be an action to the investigating officer, and then the investigating officer will read the complaint together with the evidence, together with the attachment like affidavits, and then he act on the complaint on what in his action. It's either he will dismiss the complaint or he will issue a subpoena to the respondent. What will happen next? The respondent will now file his counter affidavit. Kung gusto ni investigating officer nga need niya i-clarify, then the clarificatory hearing will be conducted. But take note that this is only optional. Rule 115, Rights of the Accused. Section 1. To be presumed innocent until the contrary is proved beyond reasonable doubt. Second, to be informed of the nature and cause of the accusation against him. Third, to be present and defend in person and by counsel at every stage of the proceeding from arraignment to promulgation of the judgment. Number 4, to testify as a witness in his own behalf but subject to cross-examination or matters covered by direct examination. His silence shall not in any matter prejudice him. Fifth, to be exempt from being compelled to be a witness against him. 6. To confront and cross-examine the witness against him at the trial. 7. To have compulsory process issued to secure the attendance of witness and production of the evidence in his behalf. Number 8. To have speedy, impartial, and public trial. Number 9. To appeal in all cases involved and in the matter manner prescribed by law. Rule 116. Arraignment and plea. What is arraignment? Arraignment is a formal mode and manner of implementing the constitutional right of an accused to be informed of the nature and cause of the accusation against him. How arraignment and plea are made? Where accused must be arraigned before the court where the complaint or information is filed or assigned. When? Within 30 days from the date the court acquires jurisdiction over the person of the accused. Who is required to be present? First, accused who must personally enter his plea. Second, the private offended party for purposes of plea bargaining, determination of civil liability, and other matters requiring his presence. Plea of not guilty when made. When the accused refuses to plead or makes a conditional plea, a plea of not guilty shall be entered for him. When the accused pleads guilty but presents exculpatory evidence, his plea shall be deemed withdrawn and the plea of not guilty shall be entered for him. Plea of guilty. Naa diri si plea bargaining. Take note, sa ato nang na-discuss adtong miagi, I talk about plea bargaining. The accused pleads guilty to a lesser offense or penalty, provided that the prosecutor and the offended party consented to such plea bargaining to have a lesser offense. Rule 117. Motion to quash. Motion to quash, it is a special pleading filed by defendant before entering his plea. So, in the grounds of motion to quash, state that first, the facts charged do not constitute an offense. Second, that the court trying the case has no jurisdiction over the offense charged. Third, that the court trying the case has no jurisdiction over the person of the accused. Fourth, that the officer who filed the information had no authority to do so. Fifth, that it does not conform substantially to the prescribed form. 6. That more than one offense is charged except when a single punishment for various offenses is prescribed by law. 7. That the criminal action or liability has been extinguished. 8. That it contains overments which, if true, would constitute a legal excuse or justification. 9. That the accused has been previously convicted or acquitted of the offense charged or the case against him was dismissed or otherwise terminated without his express consent. Rule 118, pre-trial. Pre-trial is mandatory in all cases. Pre-trial, prior to the actual presentation of evidence during trial proper, the party may offer and then the other may admit the truth of certain facts. So natay gitawag og plea bargaining, stipulation of facts, marking of evidence, modification of trial order, waiver of objections, promote a fair and expeditious trial in criminal and civil aspect of the case. So in trial, it must be avoid surprises so that both parties may have time to prepare. According to the court, both parties may have time to prepare and must avoid surprises, meaning to say, Dili pwede inig-abot sa court ma-surprise ang usa ka accused nganuman. During pre-trial, that's the time that you may lay down all the evidences you have, even your witness, expert witness, and the evidence, even object, documentary, and testimonial evidence. Because failure to present, failure to mark, failure to identify the evidences, it could not be admitted during trial unless otherwise the reason for that is good cause, and that's the only exception. In pre-trial agreements, all agreements or admission made or entered during pre-trial conference shall be reduced in writing, signed by the accused and counsel. Otherwise, they cannot be used against the accused. All agreements must be approved by the court. Take note, if these requirements wala naka-reduce writing, wala naka-sign ang accused o si counsel, so these requirements are not compiled with agreements and during pre-trial cannot be used against the accused. That's the pre-trial agreements. In plea bargaining, it must be consent to the prosecutor as well as offended party. Take note, in plea bargaining, the accused may pledge guilty to a lesser offense or penalty. Take note, in pre-trial order, within after 10 days after termination of the pre-trial, the trial judge shall issue pre-trial order. Rule 119, Trial. This is a time to prepare for trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial shall commence within 30 days from the receipt of pre-trial order. Continuous trial once commenced, shall continue from day to day as far as practicable until terminated. So, naatay scenario, na priso, dugay na kaayo ang iyahang trial. Nalapas na ang iyang supposed na sentence. Like for example, 3 years ang penalty na iyang na-commit. Then, nalapas na ang 3 years. So, the question is, the PDL or the person deprived of liberty must be released? Nganuman, yes, because it could be a violation to the right of liberty against to the PDL kay nalapas naman niyang service of sentence. So what are those instances in which criminal liability has been extinguished? So natay gitawag og death, so namatay na ang accused, service of sentence, naserbisyuan na ang iyahang sala. So that's the determination on how criminal liability has been extinguished. In arraignment, the presence of the accused is this indispensable, meaning to say, kinahanglan nga naa ang presensya sa akusado. Dili pwede nga wala ang presensya sa akusado because the purpose of the arraignment is to inform the accused of his right. But in the case of trial, lahi, kinaatay gitawag nga trial in absentia. Pwede man nga wala si akusado during sa trial. So what is trial in absentia? First, the accused must be notified. Second, that his failure to offer is unjustifiable. Supposedly, ang trial kinahanglan naa si akusado para maka-cross-examine o madungog niya ang testimony against him. Naay mga instances na wala si akusado. Unsay mga instances? Giignan na si akusado nga naay trial, pero wala siya ming adto o ning absent siya nga walay rason. Unsa may epekto ana? The arguments during trial in absentia, the accused waived his or her right to cross-examine the witness, meaning to say, nawala na siya og katungod nga mo cross-examine sa witness. So that is trial in absentia. What is judgment in absentia? Magpadayon ang trial, ang hearing maskin wala pa na si akusado. If the accused has been notified of the day of promulgation, naanay pitsa kanus-a iingon ang judgment, but does not appear the promulgation in absentia is warranted. Meaning to say, maskin wala pa na si akusado, padayon paghatag sa judgment. Padayon gihapon ang pag-promulgate paghatag sa judgment. That is judgment in absentia. Order of trial. First, the prosecution shall present all evidences to prove the charge against the accused. Pag human ni prosecutor o present sa iyang evidences, bisan sa iyang mga witnesses, then moingon siya, Your Honor, we raised our case. So that's the time nga si accused na pod ang mo present sa iyang evidences o sa iyang witnesses to prove his defenses. Second, the prosecution and the defense may in that order present rebuttal and rebuttal evidence. What is rebuttal evidence? Mauni kontra sa to ang prosecutor. Mauni ang atong gamiton nga mga ebidensya nga ato ang ikontra sa to ang prosecutor. So mauni ang atong gitawag nga rebuttal evidence. Naa by instances in which kining trial order dili masunod? Pwede nato usbon. Pwede mag-una si accused. If the accused presented lawful defense, what is lawful defense? So, diri mo gawas ang gitawag natong reverse trial. Example, si accused, it was charged with the crime of homicide. Then, moingon si accused during arraignment, Your Honor, I will plead guilty but it was self-defense. Normally, it will apply sa atong gitawag nga self-defense, defense of relatives, defense of stranger. So, kining tulo, example ni siya sa mga lawful defense. So, sa self-defense, naatay gitawag og first, unlawful aggression. Second, reasonable necessity to prevent or repel the attack. Third is lack of sufficient provocation on the part of the person defending himself. So, mao nitong gitawag og lawful defense in which reverse trial is applicable. Demurrer to evidence. After the prosecution raised the case, the court may dismiss the action on the ground of insufficiency of evidence. Number 1, on its own initiative. After giving the prosecution the opportunity to be heard. Number 2, upon the demurrer of evidence filed by the accused with or without leave of court. Meaning sa with or without leave of court, it means it is permission from the court. But there are implications if mananghid ba ka or dili. Naay epekto kung mananghid ba ka or dili. So, natay gitawag og duha ka pamaagi. Ang first is motu proprio. Motu gitawag og lack of evidence. Second is demurrer to evidence. Take note, it is remedy available to defendant. Only defendant can avail this remedy. Mao na siya ang demurrer to evidence. The question is, what if the court denies the demurrer to evidence? Then the answer is proceed to the trial and the accused has the opportunity to present the evidences during trial. Question, what if you file demurrer with leave of court? The answer is the court grants the demurrer, then dismiss because it will be the effect of granting demurrer to evidence. Unsa may meaning sa denied? The accused is prohibited presenting evidence. Maunay epekto karon na ana ka ebidensya but you are no longer allowed to present your evidence during trial. Magtagad na lang ka kung unsay desisyon sa korte base sa evidence sa prosecutor na wala nimo na present ang imuhang ebidensya. That's the effect of filing the demurrer of evidence without leave of court. Rule 121, New Trial or Reconsideration. At any time before a judgment of conviction becomes final. Take note, according to Rule 121, the rules of court allows to conduct a new trial before a judgment of conviction becomes final. The question is, muingon ang judge, you are guilty beyond reasonable doubt. Dili pa ba na final? The answer is dili pa. Because after the promulgation of judgment, you are given 15 days whether to appeal the case, whether to file a motion trial or reconsideration. What if sulod sa 15 days wala kay gibuhat? After the lapse of 15 days, the decision will become final. Take note, si accused na pa ba'y remedy nga pagabuhaton within that reglementary period? So kung wala may gibuhat si accused within that 15 days, now the decision of the court will become final. Grounds for a new trial. First, the errors of law or irregularities prejudicial to the substantial rights of the accused have been committed during the trial. Second, the new trial or material evidence have been discovered which the accused could not the reasonable diligence. Take note in general rules, the errors of defense counsel in the conduct of trial, either an error of law and irregularities upon which motion for a new trial may be premised because generally a trial is bound by the accused of his counsel. Take note, kanus ang exist ang kanang atong gitawag nga newly evidence. That evidence must have been discovered after the trial. Maskin unsa pa na ang imong pagpaningkamot, it could have been previously discovered, produced the trial even with the exercises of reasonable diligence. In material evidence, na ay kalambigitan sa kaso. Kung dawaton sa korte, pwede di ay mausab ang judgment. Grounds for reconsideration. Errors of law or fact in the judgment which requires no further proceedings. In new trial, take note, there is another trial. The question is, unsaon man tong mga ebidensya nga gigamit adtong una, magamit pa ba to siya? The answer is yes, magamit pa to siya. The order of granting new trial, the effect of the former judgment. Although, miingon si korte nga, o sige, i-grant na to ang new trial. But katong previous nga judgment, pwede to siya usbon og pulihan sa new trial. Take note, when the evidence or when the new trial is granted on the ground of a newly discovered evidence, the evidence already adduced shall stand. Kadtong mga daan nga mga ebidensya, magpadayon to o magdugang lang ta og bag-ong ebidensya para sa atoang new trial. Rule 126, Search and Seizure. Search warrant defined is an ordered writing issued in the name of the people of the Philippines, signed by a judge and directed to peace officer, commanding him to search personal property described therein and bring it before the court. Take note, and search warrant is a constitutional mandate in Article 3, Section 2 of the Constitution, stated that the property to be seized must be particularly described in the search warrant.